Hi, this is the Business Guy. Let's talk about the benefits of a Cook Islands Trust to protect your assets from lawsuits. A Cook Islands Trust is a legal arrangement that offers some of the most powerful asset protection from lawsuits and judgments. It's a popular option for individuals and families who want to ensure that their assets are safe and secure from legal predators. And then, if desired, passed down to their heirs in a confidential manner. In fact, I've set up more Cook Islands Trusts than anyone in the world, and I'm here to talk to you about the benefits of a Cook Islands Trust. There are many benefits to setting up a Cook Islands Trust. So first I'll give you a quick summary, and then I'll go into detail about each one. Asset protection. A Cook Islands Trust can help protect your assets from creditors, lawsuits, and other legal claims. Tax efficiency. Cook Islands Trusts do not increase or decrease your taxes. They're tax neutral. The income and expenses flow through the trust as if you earned the income in your own name. More about that later. Confidentiality. Cook Islands Trusts are very confidential, and the identities of the settlor, beneficiaries, and trustees are not publicly disclosed. Flexibility. Cook Islands Trusts can be tailored to meet your specific needs, and they can be amended or revoked through the aid of the trustee. Asset protection. One of the biggest benefits of a Cook Islands Trust is that it can help you to protect your assets from creditors, lawsuits, and other legal claims. This is because the assets are held in the trust, not by the settlor or the beneficiaries from whom the judge can take them away. For example, say you're sued and the plaintiff wins a judgment against you. If you have the money in the bank down the street in your own name, the judge could easily order the seizure of your bank account. The opposing attorney will simply walk into the bank with a judgment, and your bank account is frozen and then emptied in a heartbeat. You check your account balance, and all you see is a big fat zero. If you had the money in an offshore bank account without a trust, the judge could easily order you to wire the funds to your opponent's attorney. However, when your assets are in a Cook Islands Trust in the proper international bank account, you still have access to your funds, but your opponent does not. They are protected from seizure. And this is because, first, the trust assets are not considered part of your personal estate, and second, our offshore trust company/law firm is not subject to your local court orders. So our Cook Islands law firm can ignore U.S. court orders, or for that matter, court orders from the UK, Australia, Canada, etc. And that's how the Cook Island Trust works. It moves your assets beyond the reach of your local courts. Some people say, well, I don't want to lose control. You don't in a trust because your trust is drafted for your benefit. But if you had control to take the money out directly, without the trust running interference for you, the judge could order you to send the money to your opponent, and there would be nothing you could legally do to stop it. So you in control is not really you in control. You in control equals the judge in control. And for you, that could mean an empty bank account. Tax efficiency. The Cook Islands Trust we establish are structured in a way that do not change the amount of taxes you pay. For example, your trust holds assets that are not subject to tax in the Cook Islands. So the only taxes that are due are those that are due back home, as legally required. So you can consult with your CPA, and if needed, we have a network of CPA who can work with your accountant to help guide you. There are generally no taxes when simply moving money into or out of the trust, so in that way, the trust works like bulletproof glass. That is, the light shines through. That is, the tax responsibility flows through to you, as if the trust doesn't exist, but the bullets, the lawsuits, don't penetrate and your assets remain protected. Cook Islands Trusts are very confidential. The identities of the settlor and beneficiaries are not publicly disclosed. And this can be beneficial for individuals and families who want to keep their financial affairs private. So you file your taxes with this information, but the person suing you is not able to look up your trust in the public records. Flexibility. Cook Islands Trusts are very flexible. They can be structured to meet your specific needs as long as it remains within the proper legal and asset protection guidelines. They can be amended or canceled with the aid of the trustee. This makes them a versatile tool for asset protection, tax planning, and estate planning. Examples of how Cook Islands Trusts have been used. Here are a few examples of how Cook Islands Trusts have been used. One of our clients owns a business, and his employee borrowed the owner's personal truck and hit someone on a motorcycle. He was sued for millions of dollars due to his employee's negligence. He lost the lawsuit, but kept all of his assets safe and secure in his Cook Islands Trust. We also set up many Cook Islands trusts to protect assets from ex-spouses in the event of a divorce. In fact, it is one of the few tools that work to protect assets from divorce. Just be sure to set one up early, because after a divorce is filed, the judge often freezes the movement of money. Another family who was under legal attack contacted us to set up a Cook Islands Trust to hold their assets and pass them down to their heirs in a legally protected manner. So instead of your kid's ex-spouse or a lawsuit running away with half or more of your money after you die, it remains protected and beyond the reach of the local courts. Another business owner set up a Cook Islands Trust to keep his cash reserves so he can continue to run the business, even when under legal attack. So when you think of a Cook Islands Trust, you might envision paradise, yet beyond its beauty lies a marvel of financial ingenuity. In the spirit of revolutionary legal innovation and unparalleled sophistication, the Cook Islands Trust is a financial instrument that has redefined asset protection and management. A Cook Islands Trust represents a fiduciary relationship where one party, the settlor, that's you, grants another, the trustee, in our case our international law firm, the right to step in to protect assets or property as needed, for the benefit of a third party, the beneficiary. And the great thing is, in the Cook Islands, you can be both the settlor who establishes and funds the trust and the beneficiary who gets to enjoy the benefits of the trust, and at the same time keep those assets away from the reach of judgment creditors. On top of that, when you die, your money goes to your kids or whoever you designate. We typically set up the bank accounts in Switzerland, Liechtenstein, the Cook Islands, or the Caribbean. The minimum deposit in Switzerland and Liechtenstein for most banks is $500,000. Cook Islands, $250,000, and the Caribbean, $5,000 to $10,000. You might have a debit card to access your funds anytime, so you can go down and buy groceries or shop on Amazon, etc. Plus, you have internet access to your funds, so you can see your bank account anytime. You can do stock trades, or if desired, you can have access to some of the best money managers in the world who can help you to grow your portfolio even faster, all safe and secure from all the financial vultures out there. Now, what makes a Cook Islands Trust unique in this context? In 1984, the Cook Islands introduced the International Trusts Act, setting a new global benchmark in international asset protection. Embedded within the Cook Islands Trust are a plethora of unmatched features that empower it to stand tall in the world of asset protection. Now let's delve into the benefits we just discussed a little deeper. Number one, asset protection. Leading our list of groundbreaking features, as we have said, is the robust asset protection. In numerous jurisdictions worldwide, assets can be susceptible to legal judgments. But under the protective umbrella of a Cook Islands Trust, these assets are shielded. Notably, a foreign court order has no direct power here. For a creditor to even have a chance, they'd need to initiate a fresh lawsuit within the Cook Islands, navigate through the local legal intricacies and the stringent requirements of proving fraudulent transfer beyond a reasonable doubt, a feat which is by design formidable. More specifically, we have set up more Cook Islands trusts than anyone in the world, and we know of no client who has ever lost money from a judgment that has been placed in one of our Cook Islands trusts. Number two, privacy. In today's hyper-connected era, privacy is not just desired, it's imperative. The Cook Islands understands this deeply, ensuring that the specifics of the trust and its beneficiaries remain concealed from public scrutiny. Number three, flexibility. Fluidity and adaptability are at the core of modern design. The Cook Islands Trust embodies this principle, offering flexibility like no other, be it dictating terms, changing trustees, or even relocating the trust to another jurisdiction. It is designed to involve. Even if your opponent does actually file a lawsuit in the Cook Islands, which we never remember seeing this happen to any of our clients, you can contact us to change the situs of the trust to Cook Islands, south of Hawaii, to say Nevis in the Caribbean, sending your opponent scrambling to another jurisdiction where they would need to pay, let's say, a $100,000 deposit to the courts before initiating another lawsuit. Number four, sound legal framework. Innovation is futile without a strong foundation. The Cook Islands boasts a legal framework that is both robust and forward-thinking. Regular updates ensure that the structure remains one of the most sought after in the world. In fact, I've seen a number of revisions to the Cook Islands Trust law over the years to enhance this strength. The Cook Islands International Trust Act, ITA, provides a number of asset protection features, including the following: foreign judgments. A Cook Islands court will not recognize any judgment that is based on any law that is inconsistent with the ITA or which relates to a matter governed by the laws of the Cook Islands. This means that creditors cannot use foreign judgments to seize assets held in the Cook Islands Trust. Forced heirship. The ITA does not recognize forced heirship laws. Now, these are laws which give certain family members a right to inherit a certain portion of an individual's estate. This means that creditors cannot use forced heirship laws to seize assets held in the Cook Islands Trust. Bankruptcy. The ITA does not allow a settler's bankruptcy in their home jurisdiction to affect the assets held in the Cook Islands Trust. This means that creditors cannot use the settler's bankruptcy to seize assets held in the Cook Islands Trust. Spendthrift beneficiaries. The ITA allows settlers to create spendthrift trusts, which are trusts that protect the beneficiaries from their own creditors. This means that creditors cannot seize assets held in a spendthrift trust, even if the beneficiary is bankrupt or insolvent. In addition to these asset protection features, the ITA also has a number of other provisions that make it a favorable jurisdiction for setting up an asset protection trust. For example, the ITA has a short statute of limitations on fraudulent conveyance, which means that creditors cannot challenge a transfer of assets into a Cook Islands Trust after a certain period of time. If you're considering setting up a Cook Islands Trust, the Cook Islands is one of the best jurisdictions to consider. The ITA provides a number of the strongest asset protection features that can help you protect your assets from creditors, lawsuits, and other legal claims. Now, here are some additional points to keep in mind about the asset protection features of the Cook Islands Trust. The asset protection features of the ITA are only effective if the trust is properly structured and administered. It is important to consult with an experienced organization to ensure that your trust is set up in a way that will maximize its asset protection benefits. And as I've mentioned, we've set up more Cook Islands trusts than anyone worldwide. The asset protection features of the ITA are not absolute. There are certain circumstances under which a creditor may be able to pierce the trust and seize the asset. For example, creditors may be able to pierce the trust if the settlers obtained the funds within the trust through criminal means. Now, in that case, if we have such information beforehand, we would not accept that person as a client. And neither would our Cook Islands law firm or the bank that holds the funds. Overall, Cook Islands Trust can be a valuable tool for asset protection to protect legally obtained funds. Number 5, wealth and estate planning. The future is uncertain, but preparation is always in our hands. A Cook Islands Trust ensures that your wealth, your legacy, is distributed according to your desires, cutting through the potential legal tangles and ensuring continuity. Illustrating through real-world narratives paints the clearest picture. The saga of the entrepreneur. Recently, an entrepreneur client of ours, sensing potential legal, corporate, and personal litigation, strategically relocated his assets to a Cook Islands Trust that we set up for him. When the storm clouds did gather, our client lost the lawsuit, but won the war because the trust's protective mechanisms ensured that the assets remained intact. Another business person had his Cook Islands Trust with us for about 15 years. He had deposited $2 million in the trust a decade and a half ago. Our money managers were able to more than double his money twice in that period of time. So during the first 7 years, the $2 million grew to $4 million and then to $8 million in the next 7 years. Now approaching nearly $10 million, our asset protection plan not only protected the original $2 million, but the growth of that portfolio to a decamillionaire stage. Now, nearing the twilight of his journey, he was concerned about the distribution of his amassed wealth. Leveraging the Cook Islands Trust, he meticulously orchestrated the flow of his legacy, ensuring his wealth will secure not only his own financial security, but those of his loved ones for years to come. Stories like these are not mere tales, but testimonials to the transformative power of the Cook Islands Trust. With the Cook Islands Trust, we have witnessed innovations that challenge the legal status quo and put the power of the law back into your hands. And today, we have delved into one such legal marvel. So thank you for joining us on this enlightening journey. And remember, in the realm of asset protection, the Cook Islands Trust is one of your most powerful allies. To get more information about the Cook Islands Trust, visit assetprotectionplanners.com and speak with one of our attorneys or consultants. And feel free to subscribe to this channel. This is The Business Guy.